These are the worst cases for a defense lawyer. They rob your soul because there is no win. Everybody is devastated on both sides in ways that you can't imagine.
So, one of the most popular shows in years on Netflix is The Crash. And it is about a girl. She was 17 at the time, Mackenzie Shirilla, who killed her boyfriend, Dom, and their good friend, Davian, and killed them by going 100 miles an hour into a wall. She lived, she was driving, and they didn't. And she was prosecuted for murder. And she was prosecuted because the data on the car showed that she was going 100 miles an hour. She had floored it, and she never put her foot on the brake. So it looked intentional. And the prosecutor said she was out to kill Dom and Davian, and they did die. And she essentially was saying, this is not murder. I didn't have an intent to kill. But the reality is she doesn't know what she intended because she says she can't remember a thing in the critical seconds before the crash. So the judge found her guilty of murder. She is serving 15 years. Well, she's serving life, and she's eligible for parole in 15 years. But there are a lot of unresolved things in this case. So, Mark, let's start with intent, because
We start first with, I know you want to start with intent, but you said the jury and then you corrected
the
yourself and
judge,
said
it was the judge, right?
Yeah, this was a bench trial. And Harvey, you've been to my office, but I don't think you've seen this thing at my office. In my father's office, there is a baseball bat on the wall. And it's on the wall so you can pick the baseball bat off. And inscribed on it, it says, if I ever think of waiving jury, you take this bat and put it and hit me between the eyes. And so I don't understand what in the world was happening here that one would think. I mean, you mentioned the person was 17. So you could say, well, it's a juvenile case. If it's a juvenile case, you don't get a jury. However, I don't think that this person was prosecuted
Well,
as a juvenile.
she was tried as an adult.
Tried as an adult because you can't get 15 to life as a juvenile.
She was tried as an adult. The issue is, was she smart taking a judge trial? Because I think the reason she didn't take a jury trial is this jury would have been out for blood. First of all, she has got a lot of issues that on many levels, she's not real likable. And, another level, she's a normal 17-year-old just in terms of, TikTok and everything else. But there were things. And I think especially killing her boyfriend, killing these two kids, I don't see how a jury wouldn't have found her guilty of murder. I just don't see it.
Let me push back on that. Number one, most judges in a situation like that, unless you have a good indication from the judge, maybe they had done the preliminary hearing, maybe they had done a motion to suppress, something where they've had to deal with the facts of the case, they are going to be loath to acquit somebody when you've got dead bodies. I mean, it's a reality. Contrast that with juries. Juries are very diligent for the most part. And in cases, my experience doing this for decades and decades is in cases where you have a murder charge, and the question is what degree, whether it's first, second, whether it's a manslaughter, whether it's vehicular manslaughter, whether it's an implied malice murder, the kind of panoply of options that you have, jurors take that very seriously. And in this case, one of the things that bugs me about this case is you kind of zoned in on the black box. So for people who don't know, many people do, that all cars or modern cars have a computer brain, so to speak, and what a forensic person can do is download the data after a crash. That black box has all kinds of data as to when brakes were hit, when acceleration happened, when it extrapolates onto what the speed was. And it does it second by second by second.
And we should
Actually,
say in those 5 seconds before impact, she had it floored at 100 miles an hour, and there was zero pressure on the brake pedal.
and that's measured. Now, you can, on cross-examination, you can bring up all kinds of other things, but accept that for a second. Accept the prosecution's case. Then the question becomes, you're saying she wanted to kill the other two. Well, she didn't break.
This is the intent part.
Right. Now we're getting to your
Well, but
answer.
before we get
But
to the
if she wanted to do that,
hold on,
then she wanted to kill herself.
Yeah, no,
if there's intent.
And we'll kind of get into that. But before we get to intent, I still don't agree with you on them choosing a judge trial rather than a jury trial, because when you do a bench trial with the judge, you can presumably you have a better shot at taking emotion out of it. And what they were banking on, and I spoke with Mackenzie's father last week, and he was saying, look, I said to him, I said, well, at the very least, this has got to be vehicular manslaughter. And he said, absolutely. He said she should have been convicted of vehicular manslaughter, but not murder because there's no intent. So it seems to me.
But this is the problem. Intent, if you're shooting a gun, if you are stabbing somebody, and you talk about the intent and whether the intent is mitigated by rage or some kind of mental incapacity. That's one thing. Here, though, I believe they proceeded on a second degree implied malice. They were implying it. They were getting to malice because they had to imply it. If it had been a straight intent prosecution theory, that wouldn't be a second degree implied malice.
I'm sorry, they said intent. This was first, and this was intent. And what they said was that when you look at all of the facts, when you look at, she allegedly had threatened to kill him before, according to prosecutors, and she was unhinged at times. And I think you're right that, you could say that she would have killed all three of them, herself included. On the other hand, she's the only one that had a seatbelt on, although I never really understood that, because even if you have a seatbelt on, when you hit a wall at 100 miles an hour, you got to presume you're going to die. But
all you got to do is watch the videos on the internet of cars smashing into walls, and they do that as crash test dummies.
Right.
And I don't care if she had a seatbelt on or didn't have a seatbelt on. If there's no braking and she's accelerating into a wall, that isn't that is a suicidal mission.
Okay, well, but that can be murder if the perpetrator lives.
It absolutely could. But you know what else it could be? And this is where a jury, I think, would struggle. It could be somebody who had gotten into a rage, who had gotten into some kind of a mitigating state of mind, so that it was a manslaughter.
So what do you do? See, that's really interesting. Then what do you do when she says, I don't remember, once I made the turn and before I accelerated, that was the point where I just have no memory of what happened. I have a problem buying that all of a sudden her memory just goes away when she turns. But if you accept it, and that's what she said, I think the idea here is, how do you show intent for life in prison when she says, I blacked out, I have no idea?
So the first thing you would do if you're the defense lawyer, I don't know if it was done here, maybe you do. You get an expert to talk about whether or not this amnesia, because that's what it is, was likely a result of the impact and some kind of trauma to the head. If that's the case, then that gives the lawyer quite a bit to work with.
But here's the problem. Here's the problem with that. It's like, yeah, if you say, I don't even remember getting in the car and driving, yeah, I get it. But the prosecutor is saying it's awfully convenient that you remember everything, which she did, until those critical 5 seconds when she floored it and went into the wall. So what they're saying is, yeah, it seems a little more than just coincidence that you don't remember things when it really matters in terms of your criminality. That's what the prosecutor's saying.
But why? But why would you forget that 5 seconds? Why wouldn't you? If you're saying, if you're the prosecutor and you're saying, oh, it's convenient, she conveniently
Right.
forgets the last
Right.
5 seconds. Okay, well, why would she conveniently forget? There are no other witnesses who were in the car other than her. Why wouldn't she make up a tale? If what you're saying is that it was a
What's the
deliberate,
what's the tale?
I guarantee you, somebody
What's the tale?
clever like her would say,
What?
he threatened me. He said he was going to kill me. He
And
said
then
he
so
was
you
sick of
floor
me,
it? So you
and I
floor it?
floored it. I floored it because I lost my mind at that point because of this sudden rage. I never had a rage like that before. Gets a psychiatrist to support that theory. She can create. She's got the blank canvas, so to speak, to paint her own defense. If and please, if you're in the comments, I don't want to see unhinged comments. Let me see comments that actually address what I'm saying. I'm
You just
saying
made her
if
so guilty.
she could be guilty if the prosecutor was being honest about, okay, I'm going to say that she made it up, that she doesn't remember the 5 seconds. How does that help her? How in
It
the world does that help her?
it helps her by saying you can't prove I intended to because I don't remember what I was doing. So then does the tie go to the runner and you say vehicular manslaughter, which is a win for her, especially
If she, but this is where it makes zero sense. If you're the prosecutor, you don't need to get intent from her mouth. You don't, from her words. You've got a circumstantial case. You've got people who were killed. You've got the black box that shows she ran into a wall at 100 miles an hour and didn't use the brakes. The fact that she says, I don't remember what happened in the last 5 seconds, to my mind, that's worse for her. That is incriminating. She would have been better off explaining it.
but how do you
No, because you're saying she's making it up, not you. The prosecutor is saying she's making it up.
But here's the thing. There was some movement of the steering wheel in those critical 5 seconds, and I think there was an attempt to even shift the car. And so the way that looks is that
Maybe somebody was
Dom
pulling the wheel.
Dom.
Pulling the wheel.
Yeah, but the thing about pulling the wheel is that she's got control of the gas pedal. So she's on the gas. And the argument or the logic would be that Dom sees what's happening and is trying to stop her and maybe tries grabbing the wheel or tries shifting the car, and that it to no avail. But it looks like
Dom is trying to get out of the car, grabs the wheel, and she reflexively puts her foot on the gas as he's trying to grab the wheel, not out of intent, but out of a reflexive action.
Guilty.
I mean,
Guilty.
yeah. Well, she can't be more guilty than she is right now as she sits here and as we're discussing this.
Okay, so let me get to another thing. Because this one I think is going to resonate with you. So we got some of the prison records. We submitted a form and we're able to get some of the prison records since she's been in. And
where is she being held right now?
It's somewhere in Ohio. It's a prison. So she already has violations. She apparently did a video chat where she was partially naked. She has been getting drugs that were not her drugs. I think they were prescriptions, but for somebody else. There have been other things. She's also been, on the phone with her mom talking about all these guys who are sending her fan mail, that she loves certain people. And the reason I'm raising that with you is it reminds me of Menendez, because she's going to be up for parole in 15 years. And I just keep thinking about the cell phone violations with Menendez, which were used as an excuse to keep them in prison and deny them parole. If she's doing that now, there's going to be enough of a list that they are going to deny her parole, and she's not thinking about the consequences here.
I guarantee you she's not thinking about the consequences because, given her age, given the immaturity, and given the obvious kind of being a product of her age and her upbringing, this is not somebody who is thinking in long-term strategical ways. So that does not surprise me. And yes, that does resonate with me, but I don't think she's thinking parole. I think part of what she's thinking is some kind of a habeas or appellate strategy where,
She's lost two of them.
yeah, well, has she alleged IAC at this point, ineffective assistance of counsel?
I don't think so, but I don't see how this is
Yeah.
ineffective assistance. Doing a
Well, it's you're very hard. I've seen IAC. For those who don't know, kind of the last refuge for a defendant
my
who's been
lawyer sucked.
convicted. Yeah, my lawyer sucked. Exactly. Harlan Braun used to say, when people say, "Why are you charging me so much?" He'd say, "Once for the trial, once for the appeal, and once to defend the IAC." So the interesting thing about this is that it is a constitutional right to have a jury trial. To waive that jury trial is not tactical necessarily. It's a constitutional issue. Is it structural? And was she uh, mature enough to have made a voluntary, intelligent, and informed decision? I just think there's a lot there. I've
Do
tried
you
these
really?
cases. I've won these cases as recently as the last 7 years. And when I say won, I had a 9-3 for not guilty on one of these with a 17-year-old and the same kind of horrific aftermath. I will tell you, just as a personal matter, Harvey, that these are the worst cases for a defense lawyer to try. They rob your soul because there is no win. Everybody is devastated on both sides in ways that you can't imagine. The defendants or the accused family generally doesn't see this coming. The victim's family are completely harmless and innocent in this. It really is the toughest thing in the world, and it's an immense roll of the dice because prosecutors know juries are always going to come back and hit you on the vehicular manslaughter, and the fight is on the life, on the murder, and that's really a roll of the dice. As I sit here in Vegas, I'd much rather play blackjack with a lot of money than have to roll the dice on a youngster's life for the rest of their life.
But that's what had to happen here. And again, I get back. I just do not see ineffectiveness of counsel by choosing a judge trial rather than a jury trial. I mean, a judge. The best argument they've got is you got to prove intent beyond a reasonable doubt. And there's no proof of intent because you can't show what she did. They said she had blackouts at times, so maybe it was that. And they were banking on the judge giving pause to the intent, where the judge would say, "Okay, we'll do vehicular manslaughter." I don't think
Know
that's
what the statutory
ineffectiveness of
scheme is
counsel.
where she was convicted, but I know in California, part of the problem is if you are convicted of vehicular manslaughter, the sentence on the high term or on the high side is almost equivalent to
No,
the
not here.
minimum on a second degree.
Not here. I mean, and there was a good chance that she would have been sentenced more like a minor than an adult because she was so young and had only driven a year. So I think I think the gamble was smart, but it just didn't pay off. I mean, gambles don't always pay off. You know, the thing.
You're one of the first lawyers that I've talked to who has defended the waiving of jury.
Because I think this was so incendiary, and these victims were sweet, and
They always are. That's the thing. By the way, when I started practicing, DUIs didn't even have, we talk about .08, right? Or .10 or .15. They didn't even have that when we first started. It was because of that there but for the grace of God go I phenomena that legislators and judges finally came to their senses on these kinds of cases.
It's still but for the grace go I.
Right, but right. Look at what's happened in the last 40 years. And to some degree, Mothers Against Drunk Drivers and that movement was instrumental in it. It started with driving under the influence, changing the perception. It evolved into what you have here, which is charging what was originally called Watson murders, which are implied malice. And it's evolved into this idea that even absent some kind of a toxicology report that shows somebody who's under the influence, even absent being under the influence, if you had notice and you drove recklessly, that itself can supply the implied malice for murder, which is an interesting development when you look at it. Something that the reaction is, this was an accident. This was an accident. I didn't mean to. That doesn't really apply anymore.
I want to get to the parents in a minute, but I just got to stop you because I actually wrote a law review article on this when I was in law school because it just fascinated me.
Was that in this century or last century?
Okay. Yeah. Okay. So it was about exactly that you could have two people and they do exactly the same thing. They go to a bar and they get drunk and they get in their car and they drive home the same distance. One of them actually makes it home without a problem. Well, makes it almost home, gets stopped and gets a DUI and nothing happens.
Nothing happens. Right. It's
the other one.
And by the way, when you wrote
Well, hold on.
What was the penalty for a first offense DUI?
This is what I'm getting at. I mean, it's essentially probation. It's 6 months, but it's probation. The second person is driving down the same kind of street, and a kid runs out, and they killed the kid. That person gets tried at the very least for vehicular manslaughter. So that person is going to go to prison for years. The other person is going to probably get probation. Yet their mental state, their state of mind, their intent was exactly the same thing. The difference is bad luck. That's the difference. Bad luck. That in one case, a kid ran into the street, and in another case, the guy made it, up until the police officer stopped him and he didn't hit anybody. But they're treated radically differently with the exact same state of mind. So what you're doing is you're punishing for vengeance. You're not punishing for bad conduct. And I've been obsessed with that since I was in law school and wrote about that. But it's always really struck me.
I haven't read this. I haven't read and I would like to. But did you frame it as theories of crime and punishment?
Yeah.
I mean, was that okay?
But that's what it is.
What you were saying, that this is not rehabilitative. It is more through the prism of retribution, which is another equally robust.
I'm not even thinking of it as rehabilitative. I'm thinking of it as punishment. That what do you punish people for bad acts? The acts are exactly the same in terms of somebody going to a bar, getting drunk, getting in a car, starting it up, and driving on a street. The only difference is a kid ran out in one of those cases, but the conduct was the same in terms of bad conduct. And you're punishing people for a result that is beyond anybody's real control. It's just, you're looking for vengeance in one of the cases. And that's why one guy literally never spends a minute in jail and the other guy spends years in prison.
Yeah, and it's a roll of the dice.
Okay.
Literal roll of the dice. So I have one question off topic from Crash. As we were getting on the air.
But can we just say before we do before you do it, we're going to get into the conduct of Mackenzie's parents in a minute. But go on.
Okay. Well, this just occurred to me, and it's completely off topic, but it's Lively and Baldoni. Did you see the order that Judge Lyman, as we tape this, it's Friday, we're going to drop on Saturday. Judge Lyman, who was the judge presiding, who gutted Blake Lively's case, and then they instantly went in for a mediation. By the way, I know I promised you I wasn't going to abuse by the way.
But you did.
My theory, so to speak, on the reason that they went to private mediation immediately seems to have been borne out. I don't know if you know this, but it is my understanding that Lively, and I'm told that Lively's did make a claim against her attorneys. And as I think you and I discussed many weeks ago, I thought that was exactly why they went running to Brian Friedman who represents Baldoni to get into a private mediated settlement, because in California, there's a unanimous California Supreme Court decision which insulates the lawyer from a malpractice claim.
Yeah,
And
but she still has to approve it.
well, yeah. Well, I don't think she can do it. I don't think at
No, no,
this
no.
point,
She has to
because she
approve
went
she has
through.
to approve the settlement. So
Yeah,
if
but
it
nobody, I don't think anybody told her that or informed her. This is my guess. Maybe they did, but my guess, and I'm going to say that, is that they ran her into the private mediation, told her to settle. Now, I think there was a lot of people who were making the claim that Judge Lyman was going to give zillions of dollars. He just entered an order, told them to brief in a very short period of time and a very truncated limit on what they could say as to what he can actually award
you're talking
and
about
on what
attorney's fees, her
basis.
attorney's fees.
Correct. Remember
Well,
when they came out,
it's a bizarre case because the way it's written in California is if you file a sexual harassment suit and then somebody files a defamation suit against you and that defamation suit gets dismissed, you can get the person who filed the sexual harassment claim can get attorney's fees. But the twist here is the sexual harassment claim got dismissed too. So how is it that somebody whose sexual harassment claim gets dismissed can get attorney's fees from the other side who's alleged defamation, and they throw that out too? That's where I think Blake Lively has severe weakness.
I do too. And this idea of somebody sold her on the idea that, and her lawyers are out there proclaiming victory because they think they're going to get some astronomical award. The order that was just issued by Judge Lyman, if I were to handicap it right now, I would tell you I don't think that there's any way that they get punitive damages. I don't think there's any way he's going to triple anything. And I think he's going to compartmentalize or silo any attorney's fees award as just a portion of what was spent. So talk about a Pyrrhic victory. I mean, I don't even know. I think victory you can almost be sued for defamation for calling it a victory.
Okay, can we get back to Mackenzie, please?
Yes, we can.
Oh, good.
I wish Branson had some footage of the parents, because if Harvey, pretend you're not running TMZ and you're running a crisis management firm, could you use these parents as exhibit A of what not to do if you're involved and your child is involved in a horrific situation?
So here's where I think I disagree with everybody, because I know people are saying, oh my God, the parents, can you believe the parents? I don't think the parents are bad at all. And I'll tell you why. For two reasons. One is, I mean, the dad's getting dragged because he said, yeah, my daughter smokes marijuana. What am I going to do? The reality is that's true. And that she is 17 years old, and that you cannot control a 17-year-old and stop them from using marijuana. And the dad said, look, I used it when I was a kid. I can't stop them. And, honestly, in many cases, marijuana is a win if they're not drinking. So, yeah, I mean, kids smoke marijuana. So the fact that the dad was open about it and was real about it.
I'm with you on that. I don't fault that at all.
Okay. The second, but the second thing is that, the problem I have is, why did they let a 17-year-old girl live with her boyfriend? And then all of a sudden, the parents could become the fall guy for the child, where the jury might have some sympathy for her, saying, this is the way she grew up. So if that's an issue, in a way, it's a good play to put that out in the open, because I think it creates some sympathy for Mackenzie.
Well, there is a aura of, oh my God, now we have an explanation for how we ended up here, right? I mean, isn't that kind of the lesson to be learned here. But if you're actually trying, if you actually are not worried about the 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 substance of it, and you're looking to try to generate some kind of result, and that's why I said crisis management. I just think the approach and the messaging makes zero sense.
Why? I mean,
I just
what
don't
was your
get it.
what was your problem with it?
But I think you've got to get up there and you've got to say, you kind of own it. And she did this. And yes, she's immature. And yes, we've heard for decades about young men not having fully developed frontal cortexes. And we've heard that young men up until the age of 25 can't do it. But it goes to some degree also, it applies to women as well. And you could talk about that. You could talk about or you could have at least and somebody have a come to Jesus talk with this young lady and tell her that if she ever wants any hope of getting out, that she's got to come to a point where she recognizes all of the damage and the ripples of damage that she's caused.
Yeah, and and her dad said she was remorseful. The family, Dom's family, says she wasn't. But wait a minute, you had said you had a problem with the parents and that they did a bad job. Tell me why.
Yeah, because if you're doing some kind of crisis management, the last thing you want to do is throw more fuel on the fire. First of all,
What was it?
just shut up and
What
put
was
your
the
head down.
fuel?
I just thought they just came across as tone deaf. I guess is the best way I would put it. I just don't. I think you watch when they speak, especially in the uh, the documentary for lack of a better term. And it just gives you a bad feeling. You don't have the zeitgeist stuff. It is not compelling to me.
But to the extent you feel that way, doesn't that benefit Mackenzie?
Well, yes, it does in a perverse way, but it doesn't really help her at this point.
No, no,
You know
no.
what I
But
mean?
but I mean, listen. During I get it after the fact, but the parents are the parents, and so to the extent the judge knew about the parents and knew about her family life, if you're right, if that were the judge's perception, he'd lay some sympathy on the kid.
If you had used it in real time, if it had been done in real time, if it wasn't kind of post hoc, that's part of the problem
I
here.
just
I
think
mean,
they were.
yes,
I just think that look, they didn't sob on camera. Okay, well, they're not going to be performative if they don't sob. Some people don't sob.
agree. I agree.
I mean, I did not have. I'm in the minority here from the people I've been talking to, people at work and everything.
You know,
They,
today you're really on an island by
I'm
yourself.
totally on an
Notice
island.
that.
Totally on an island. But I got to tell you something. We got something coming up that I can't wait to talk about. And I think you're going to be so interested. And I definitely want to do a Two Angry Men podcast on it. But it's one of the most famous deaths ever. And we're doing a network special on it that airs next month. And when we get closer to it, I just cannot wait for you to see
Okay,
this. And
wait, you're going to tease it and not say what's the most famous death ever?
it's what I do.
Yeah, jeez.
See you next week.
Wait, it's TMZ, teasing man.
There you go.
Got it.
Bye.
Okay.